Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, negotiation, conciliation, ombuds, and of course, early neutral evaluation. My name is DrChinweEgbunike, a postdoctoral fellow at the University of Brighton, United Kingdom, and the fellow of the American Bar Association, section of dispute resolution. I'm delighted to welcome Dr. Anita Dorczak to the EVER Show. She is a Canadian lawyer, mediator, and trainer with over 30 years of experience in conflict resolution. Dr. Anita is a past president and lifetime member of the International Listening Association, a certified listening professional, the current co-chair of Collaborative Law, American Bar Association section of dispute resolution, and a member of the Canadian Bar Association. She is also a member of the International Academy of Collaborative Professionals and the Global Collaborative Law Council. Dr. Anita wears many hats, so I've left a link to her profile below. Welcome to the show. So it's so good to have you. Let me start sharing.
Hello, and thank you. It's awesome to be here. As I said before, I'd love to be with you. I'm far away across the big water that doesn't look so warm as you are, but it's great to be here. And I want to start by saying, Chinwe, thank you for doing what you're doing. It's great. I think it's great what you're doing. I was so delighted to meet you. We were sitting together in Las Vegas at the conference, right? We were sitting next to each other and coffee and
cookies.
So it was this year. So it's great. And I think the podcast like yours is very much needed because it will open the way of thinking about how to approach conflict and what to do with it.
Thank you so very much, Dr. Anita, for all your support and kindness towards me. I'm very grateful. And can I say that you're one of my favorite person to speak with, you know? So I'm so happy having you. Finally. So without further ado, the first question is, what is collaborative law and its impact on in Canada?
It's actually fascinating because there has been an impact that is measurable in a sense. So collaborative law, as probably a lot of people who would listen to this may know, is just a dispute resolution process that is completely voluntary and is confidential and is based on contract. We call this contract the participation agreement, and the people who want to come and have the conflict resolved sign that contract together with the lawyers. And in it, we say, we undertake to actually take steps to resolve the conflict out of court. We will be acting in good faith. We are going to show all of the necessary documents, put them on the table. So everybody who has a question about anything, how much do you make? You know, what was your income last year? How much is this house worth? All of these documents will be exchanged and we will look at them together. So the exchange of documentation is crucial, and it's based on contractual obligation to do that. And there is one important catch in it that caused a lot of discussion in the States, and this is the withdrawal provision. So in the contract, it says that if the lawyers cannot help resolve, and as a group, because we work as a team, so is not able to resolve the conflict, then the lawyers must not represent the clients in the future any litigation. So voluntary promise of, you know, talking in good faith, showing all of the documents that are necessary to resolve the dispute. And if we fail, the lawyers are out. Isn't that great? That's wonderful. I love it.
All right, thank you so very much for that. So is there a history behind collaborative law in Canada?
Well, yes. So you may have heard from the American colleagues that,
Yeah.
a certain lawyer by this name that everybody knows, Stu Webb, he started thinking about it. So I'm not going to repeat that, but what I will say is a little anecdote, because Stu came to Canada. Of course, sometimes he came with Ron Uski, and they would give these workshops, these trainings, right? So he came to our province as well. It was probably about 2000 or so, and give these trainings. And there was a small group, and then the group started growing. So we now have groups of collaborative practice in all of the provinces in Canada. I live in Alberta, so that's close to the beautiful Rocky Mountains, where we have some snow now at the peaks, but still beautiful weather, very warm. So Stu came here, gave this training, and then he also trained and gave workshops at the conferences of International Academy of Collaborative Professionals. So I had the pleasure of attending them. And he also was kind enough to a couple of my presentations at the conference.
Wow.
And it was so cool, because we met at a breakfast. And I said, "Good morning, Mr. Webb." I'm very formal. And he says, "Well, I don't have time really. I'm going to this presentation on humor." I go, "Okay, I'll see you there." And it was my presentation. So it was pretty funny. So that was in Philadelphia.
Wow, that's great.
It's wonderful. Sometimes it takes one person who starts thinking in a different way about approaching conflict. So I personally am very grateful to Stu, and I have a great deal of respect for him, that he was able to change. We talk about this paradigm shift, that we look at the conflict differently, and it doesn't have to be like this. It doesn't have to be all, just we are fighting, it can be like this, we can just embrace and, be human and talk, because resolving disputes really is all about communicating and talking. And that's what's needed. Talking, listening.
Okay, thank you so very much. So is there any measurable difference or impact on the cost and time frame for settling via collaborative law when compared to litigation and mediation?
Well, there have been some studies, and they may be still on the website, actually, of the International Academy of Collaborative Professionals, IACP. There was a study done, I believe, about 2014 that talked about the resolution rate, and was very high. Wrong, but was somewhere in the 86-90%. And also, interesting comment was that the people who engaged in that process were very pleased with it. So what would be the best outcome, right? You resolve the conflict and the people are pleased with the outcome. That's great, because when you think about courts, yes, the case would be resolved. The conflict doesn't necessarily get resolved, right? But then is everybody pleased leaving the courtroom? Probably not. Because there will be losers and there will be winners, right? But going back to Canada and the impact, sorry, I just adjusting a little bit the camera here. So talking about Canada, I'm just sitting wrong, but anyway, okay. So yes, there was impact. So collaborative law, now we don't have the act like in the States. We don't have the law per se. We don't have UCLA. But in our Divorce Act, what happened was collaborative law came to dwell in the definition of family dispute resolution process. That was the change in 2021. Our divorce law underwent a huge change. We got rid of this horrible term called custody. And, instead of that, we now have decision making. We use different terminology. And now we, the lawyers and the clients, and I'm taking it into the family arena, we have to sign and a form in the papers for court saying that we will try to use the family dispute resolution process. Now, I'm going to read the definition because I'm very excited about that. Section 2.1 of the Divorce Act in Canada says, family dispute resolution process means a process out of court that is used by the parties to a family law dispute to attempt to resolve any matters in dispute, including negotiation, mediation, and collaborative law.
Oh, yeah.
I'm so proud. I'm so grateful this appears because
Yeah,
now lawyers have to know about it. And,
exactly.
a lot of lawyers would not know about it necessarily initially.
Yeah, you're right.
That's the impact. That's the impact in a sense that now we have a reference to this process of dispute resolution in the
Yeah.
divorce in Canada.
Yeah. So when it comes to mediation, is it cheaper to go to use or utilize collaborative law?
It really depends on the means of the parties who come to see us.
Oh, okay.
Generally, you may have heard some comments that, well, there is free mediation available, of course, under some of the government programs. And there's some mediation for people who earn a certain level of income, and then they can actually come and meet with a mediator for free. And then there's, of course, the mediation that is in the private realm, just like collaborative law, which is in the private realm.
Yeah.
So we, in the collaborative law, the way we approach that is we have in our contract, in the participation agreement, we have a clause that talks about funds being made available by the parties so the process could go on and conclude. So we talk about the costs, which normally in litigation, nobody really talks about the costs. They're awarded at the end and somebody just walks out and is crushed because there are thousands of dollars to pay. But in the collaborative process, we address it and we gauge the number of meetings, the duration of the meetings, having the cost of the process in mind.
Okay, thank you so very much, Dr. Anita. How about, when I think I've listened to some collaborative lawyers talk, and they always talk about collaborative law and collaborative law practice. So what's the difference between the two?
I don't really see a lot of difference. Okay. Collaborative law term that was coined, years ago. Practice to me means just engaging in it and resolving conflict in a way to take people out of court, which I really, really, really love to do. Why? There are lots of reasons, but one is that people are empowered to actually build the resolution that will help them move in their own life. It's not a decision that is, decided and put upon them by the judge saying, you will do this and this and this. It's my own decision. And if I make my own decision, I like it and I must respect it. But, when it's imposed by somebody else, another decision maker, then a lot of times it may not be respected and followed. And that causes a lot of issues then, because these people go back before the judges, they continue to quarrel, they continue to take the time, and the resources that could be actually used for some perhaps other cases.
Okay. Thank you so very much. So that leads to the advantages. So can you, are there more advantages associated with collaborative law?
Well, to me, other than what people always talk about, that it's less cost and quicker. To me, the biggest advantage is that it opens up creativity. We can actually work with the couple, and the couple is free, or maybe more than a couple, depending on the nature of the case. But we can actually together build a solution that sometimes might not be even available under some legal rules. Creativity comes in and we can engage in it fully. And that was the first, for me, the magnet, the excitement to get trained in collaborative law, that I did not have to follow every single letter of the law. We could work in a creative way. So to me, that's the biggest advantage. And of course, then there are the usual, well, maybe it will cost less. Maybe it will be quick. Well, maybe quicker, but I have had collaborative cases when we waited for months for a document that was not available from the government. So it's fault of anybody. We had to wait, the whole team had to wait for a few months to get a pension statement, for example, without which we couldn't complete the division of matrimonial property in those days. So, you know, it's relative, but you cannot really be very creative in litigation, can you?
No, no. And so how about the challenges? Do you think collaborative law has got challenges associated with it?
Yes, yes, and I think it will continue to be so because a lot of when people are in conflict, and I think it's our culture and our you know, social media and television portraying lawyers as fighters in court. So this has been a predominant image of a lawyer, the lawyer who will go to court and protect your rights and fight for you. And I think that's what people carry in their minds. And I think that's, unfortunately, it's going to be a long time to get rid of it. Will we get rid of that image completely? Probably not. But by talking about other types of dispute resolution, like collaborative law, like mediation, right? Even good old-fashioned negotiation, just by doing what you're doing, Chinwe, and, you know, just having organizations, putting together conferences, and reaching out to people through different organizations, you know, just making people aware. It's the question of awareness of the audience, being able to understand that there are other options available other than litigation. So it's a lot of work. I mean, in our organization, we had an announcement on the radio. We went and talked to other groups. So it's really about raising awareness that this process exists. So yes, that's a big challenge, and we are working on it, and we'll continue to.
Okay, thank you.
Should work on it.
Thank you so very much. So what models can be used in collaborative law?
Well, I'm not sure what you mean by models.
Okay, can it be facilitative, directive?
Oh,
yeah.
I think we are now kind of going into mediation a little bit, because facilitative, you know, transform, narrative, they're sort of the different models of mediation. It's an interesting discussion whether or not we can bring the mediator to the collaborative process. That has been a bit of a in trend, a lot of discussion there. You may have been present at the conference actually when this was discussed. To me, going back to the conversation, because really it's negotiation, to me, it's all going back to the ability to listen. For me, it's the base and the foundation of good collaborative process is the ability to be respectful and to allow the space for the other to express what's important, and then to listen to it without judging, without saying, that's so stupid, I would never do that. No, don't say that. Just listen, and then let it be. And let it just be with you, and be able to have in your mind, you know, a few potential alternatives to see which one would be best for this particular family, for this particular, you know, group of people that come to see about conflict resolution. So my free Canadian cents, that is worth nothing now in American, but that's okay. It's worth something in pounds, right? It's still... No, it's not.
All right, thank you so very much. So I wanted to ask two more questions. So can it be utilized in all cities in Canada yet?
I think it's, I cannot say all cities, but I think I looked here in preparation for this, and there are groups, you know, when we go from Canada, which is a beautiful country, from the West, British Columbia. There are a lot of groups in British Columbia, then in my province in Alberta, then there's in Saskatchewan, Manitoba, Ontario, Quebec, Nova Scotia. So almost in all provinces. And then from the provincial level going down, we would have also groups in the cities. So for example, a group in Edmonton in Alberta. We have a group in Calgary as for example, two groups. So there may be cities and provinces, so different levels of organizations. But yes, we do function, and we are hopefully growing with people like yourself, younger people who are curious and want to ask questions about how to deal with conflict. Does it always have to be court? No, it doesn't.
Yeah. Thank you so very much. So, what is your advice for potential users and people pursuing a career in collaborative law?
Just do it. So get trained on a serious note. Get trained. So training involves mediation, negotiation, and collaborative law. So get trained. Yeah. Once you do that, you will get to the point of enjoying that practice. And that's another benefit, because when we have collaborative groups and we work together, it's not only that the conflict gets resolved, but it's about how it gets resolved. And if we work together and we like each other and we respect each other, it creates a different climate for conflict resolution, which is really cool. So and that's what Stu Webb talked about 30 years ago. And he started practicing in 1964. And he actually wrote that famous letter to Justice Keith in 1990 on February 14th. So he had been practicing for many years. And then he said, resolving conflict can be fun. When we work together, actually can be fun. I'm not sure if that's the word he used, but it doesn't have to be always serious and doesn't have to be always adversarial. Okay. So if that's the last question, Chinwe, I have a question for you, if I may.
No, I have one more question.
Okay. Okay.
So what is the future of international legal research via podcast, particularly ADR, in this case, collaborative law? Yeah.
Well, let me grab my magic wand. Okay, so I have my magic wand, and here is what's going to happen. It will grow, okay? It will grow. I think it's very much needed.
Yeah.
Okay. And I think the more interesting you make it, the more people will be listening to it. So essentially what you're doing, trying to get people from different countries, making it really international. And once we form these connections on an international arena, then the ADR actually will become better known and can grow more. So it makes perfect sense for me. So I retire my magic wand, but remember, I waved it, so there is no way out.
All right, thank you so very much. It's such an honor having you on the show. It has been fun, but at the same time quite educative. I've learned so much, and of course, it's a masterclass. Thank you for sharing your insights, perspectives, and the learning you shared with us today.
No, I'm not getting you off the hook. I'm not getting you off. I have a question for you.
Okay, go on.
Okay, now you're on the spot. Listen, I'm reading from your intro. So you're saying, I dream of seeing ADR given equal footing with litigation resolving disputes.
Yeah.
Okay. All right. How about giving ADR not equal footing, but it beyond litigation? So that would be the dominant way of approaching disputes. What do you think?
Oh, well, I think they're still the same thing. I think it's still the same message. That's my thinking, because essentially what I was trying to say is for ADR to be recognized in schools, at home, trade unions, other than litigation, because you find out that kids and students, they don't teach that in schools, and even in the universities now yet compulsory. So I think equal footing and being dominant, you said.
I think we should try to elevate it, and make it the dominant trend as a
Dominant trend. Oh, yeah.
Yeah.
Okay.
Yes,
Yeah.
to make people aware and to teach it at schools,
Yes.
as I think, to teach it at universities and talk about it as the first way, the dominant way, and investigation, put it at the very end of all of the options available to people to resolve conflict.
Exactly, 100%, 100%. I totally agree with you. Because Dr. Nathan is very like junior scholars like myself on looking for job in ADR in universities, and you find out that most universities don't offer ADR, and of course you have to start applying for something else, and that's not my passion to teach something else, So it's it's quite a bit of a problem, yeah.
But
If it's litigation, and it's never ending,
Yeah.
So
no, I think we agree. Awesome. Super. Thank you so much for having me.
Oh, thank you so much. So let me sign out again. Let me do my signatures signing out.
Of course. Thank you.
Thank you for your insights, perspectives, and learning you've shared with us. I believe that potential users would embrace or will embrace all you have stated herein and opt for ADR, particularly precisely collaborative law. Thank you so very much, Dr. Anita, for coming on this show. I'm grateful.
So thank you, Dr. Chinwe. Do what you're doing. Awesome being here with you. Take care.
All right, cheers, you too. Bye.